Welcome back to Court TV. We're going to switch gears here. If you want to keep watching Uvalde, we're streaming it online at courttv.com, and we'll be going in and out of it. But right now, we want to turn our attention because a sentencing hearing is coming up. This is the case of a man who was convicted of the murder of his wife 24 years later.
Last month, a jury found Paul Hicks guilty of kidnapping and murdering his wife, Regina Hicks, whose body was found in a pond days after he filed for divorce. This was back in 2001.
Prosecutors argued that Hicks rendered his wife unconscious before placing her in the passenger seat of her vehicle and then driving it into a pond where she eventually drowned.
Before we get you back into court, here's a look back at this trial for Paul Hicks.
There's no evidence that Regina Hicks was driving that vehicle. There's no evidence that Regina Hicks floated from the driver's seat to the passenger seat, which is what would have had to happen if she was going to commit suicide. Her relatives will also tell you, when they saw her that day, she was not suicidal.
How would you describe her relationship with Paul Hicks?
She told me it was getting very rough. Just maybe 3 weeks before she came up missing, she said she was in the process.
Stop. In the weeks leading up to her disappearance, did they separate? Were you aware of that?
Yes, they did separate.
Please read what you heard the defendant say.
I hate you, die bitch, excuse me, but you're a ball and chain, old lady, fat cow, excuse me again, slob.
We could see an image of something there in the water. And so he reached down. When he reached down, he just hollered back and told me that it's not a jet ski. So he hooked that rope onto what turned out to be the, what do you call them on a Camaro on the trunk? Spoiler. It didn't take very long, and then the sheriff, Borgia, he's the one that got the purse out of the water.
These were the pants that Regina was wearing when her body was recovered, blood caked in between the belt and the belt loops.
Regina was unconscious when she died in that Camaro. She otherwise would have far away out of the Camaro. That's just a natural instinct that anyone would have. You have a child without a mother and a family that's been fractured and the community in flux. And it all started when the defendant, Paul Hicks, 24 years ago, launched his wife's coffin in the shape of a 1994 Camaro into the Whetstone Pond.
No footprints, no soil samples, no handwriting analysis or weapon linking Paul to these two alleged crime scenes. Back in 2001, they are investigating, so it's not like time has withered all this away. And even if it did, your obligation under the law would be to hold it against the state, not against the criminal defendant.
In the state of Ohio versus Paul Daniel Hicks, 2025-0284, on the indictment for count 1, the murder, the jury finds the defendant guilty of murder and unclassified felony. As far as count 2, then, the jury finds the defendant, Paul Daniel Hicks, guilty of murder and unclassified felony, which was the proximate result of the defendant committing kidnapping, which is a felony of the first degree.
All right, that is a little preview, and boy, his reaction when he was found guilty,
Yeah.
He was shocked.
Yes, he was.
Yeah. All right, let's go into the sentencing hearing now and see what happens to old Paul Hicks.
Again, we are here then for purposes of sentencing. We're here on a trial verdict with regard to 4 counts. The first count is a charge of murder, unclassified felony, has a 15-year to life sentence. Count 2 is also a charge of murder and unclassified felony, and count 3, a charge of murder and unclassified felony. Those 2 charges, counts 2 and 3, by law would merge with count 1, which the state has elected to proceed on for purposes of sentencing today. In addition, we're here on count 4, a kidnapping charge of felony of the first degree that has a 3 to 10 year prison sentence that could be imposed and a fine up to $20,000. Are those the penalties and charges that the parties recognize we're here for?
Yes, sir.
All right. And is there any reason we should not proceed to sentencing at this time?
No, Your Honor.
No, Your Honor.
All right, very good. The court did not receive any restitution request in this matter. There were numerous victim impact statements that were received by the court. I can assure anyone that's here and anyone that has not appeared here today as a purported victim to the case that I have reviewed each of those individually prior to commencing the sentencing here today. I understand that there are various family members that would like to address the court with regard to sentencing. Is that correct, Mr. Kissett?
Yes, Your Honor.
All right. If you would have them come forward, I would like them to come to the podium. They could give their full name for the record and then what they would like me to know.
Your Honor, first, Janet Hecker. I will read Janet Hecker's statement to you.
Okay.
It's a two-page statement. Janet Hecker testified at trial. She is an aunt of Regina Rowe. Your Honor, Paul Hicks, you are a monster. You stole Montana's future. He had a loving mom, Regina, and a loving grandmother, LaSala, and uncles, cousins, great aunts, and great uncles that loved her. You took that. You took that. Not only did you kill Montana's mom, you kept him from us. You and your mom would not let us see him. Your mom, Jewel Hicks, said she loved Regina like a daughter. Then why would she not take her son, Montana, to her grave? Cite how your son was taught to lie. No matter what he did, you're going to lie for him. So now my wish is that you both suffer as much as we have. I hope Paul Hicks and Jewel Hicks see Regina's face every night of their lives. I hope you, Paul Hicks, get a disease that eats you away, slowly and very painfully. I hope that you live like that for at least 24 years, and your mom can watch as you suffer, so she can feel some of the pain that we have felt with Regina. It was so wrong of you and Jewel to keep Montana from my sister LaSala, the one thing she had left in her life after Regina. I hope you rot in hell, Paul Hicks, and your mother, Jewel. Regina was a loving, caring person. She loved her niece Shelby and her nephew Brandon very much. She never even got to meet her other nieces or nephews because of you, Paul Hicks. Paul, you are a monster. You think you're above the law, but they finally got you. Janet Hecker. Your Honor, next we would ask.
All right, we're going to slip in a commercial break and get back to this. Boy, the emotions come out in a sentencing hearing.
Oh, yeah, definitely expressing those emotions. They are mad.
All right, Cousin, coming up next. Stay with us. Welcome back to Court TV Live, along with Kelly Craft. I'm Ted Rowland's going to be with you on this Friday. We're in Ohio, a sentencing hearing underway for the drowned wife, murder trial defendant, and now convicted killer, Paul Hicks.
The possibility of life in prison, that's what he's facing after a jury found him guilty last month of 3 counts of murder and 1 count of kidnapping in the death of his wife, Regina. Her body was found in the passenger seat of her car, submerged in a pond, 3 days after Paul filed for divorce.
Let's head back to the courtroom now. Up next is a cousin of Regina's.
Your Honor, next we would ask Lisa Hersha.
All right.
To approach the podium.
Your Honor, I'll object for the record for any commentary or statements against any of Paul's family. They're not being sentenced today. It's improper, it's inappropriate.
All right. If you can refrain from any comments with regard to Mr. Hicks's family, I think that would be appreciated. Obviously, any comments that are directed toward the defendant are available to be heard. Would you like to go over with your statements?
Yes.
If you could state your name, spell your name for the court recorder.
My name is Lisa Hersha, L-I-S-A-H-E-R-S-H-A. Regina wasn't just a headline, not just the drowned wife. She was my cousin. She was my friend. Regina was intelligent, far more intelligent than you. She had a rare kindness and a heart that would have only grown stronger with time. She brought light into the lives of others simply by being herself. She would have made a real impact on this world. I remember her beautiful smile and her infectious laugh. I remember sleepovers filled with laughter and summers spent relaxing by the pool. I remember Regina's excitement when she got her driver's license, her first car, and the freedom that came with it, driving with the windows down and the radio up. I remember helping her paint her bedroom and talking about futures and dreams that she would never be allowed to live. My final memory of spending time with Regina was after I had my daughter. I brought her over so Regina could meet her. She talked about how excited she was to become a mother herself one day. That moment should have been a happy one. Instead, you poisoned it. Your comments made that visit uncomfortable. After that day, our conversations grew shorter. Phone calls became less frequent until they stopped altogether. That was not coincidence. It was deliberate, calculated, and controlling. Regina was systematically isolated from the people who loved her. She was made to believe her family and friends were the problem, dangerous, unworthy, something she needed protection from. In reality, you were describing yourself. That is how manipulators operate. That is how abusers maintain control. It took Regina years to see the truth, years to recognize that you were toxic, years to understand the harm being done to her, years to gather the courage to leave and begin a safer, healthier life, once finally free from your control. And you could not allow that. When Regina went missing, you showed no concern, no urgency, no fear, no love. While her family and friends searched and prayed, you did nothing. You carried on with your life as if nothing had happened while we were living nightmare. That same indifference has followed you into this courtroom. Throughout this entire trial, you have shown no emotion, no remorse, no regret, no humanity. Your emptiness now speaks just as loudly as your indifference did then. You are a liar. You are cruel. You are selfish beyond measure. Your actions did not contradict Regina's judgment of you. They confirmed it. This was not a tragic accident or a momentary lapse in judgment. This was a calculated act of control by a man who believed he had the right to decide whether his wife lived or died. And you made that choice. You made the choice not to get Regina medical help. You made the choice to place her in her car. You made the choice to submerge that car in a pond. And you made the choice to walk away. You erased her from her son's daily existence. You silenced the voice that would have guided him. You stole the mother who would have comforted him, protected him, corrected him, and loved him through every stage of his life. He grew up without her wisdom, her reassurance, and her presence because you chose control over humanity. For 24 years, we have lived with the consequences of your choices. 24 years of grief, loss, and unanswered questions. Those consequences do not disappear simply because you ignored them. Today, finally, your choices have caught up with you. For the first time, you are being held accountable. Your actions were deliberate, your silence was deliberate, your cruelty was deliberate. Life without the possibility of parole is not about revenge. It is about accountability. It is about protection. And it is about making clear that no one has the right to erase another human being simply because they refuse to lose control. Anything less than life in prison without the possibility of parole would suggest that this kind of violence can be overlooked. It cannot. Regina will be remembered forever. You will be held accountable and forgotten. Thank you.
I just would like you to know that.
Still with us, former Deputy Public Defender for LA County, Philip Dubé. Philip, strong words there from the family members of the victim.
Oh, yeah, she vituperated him, literally, and she had every right to. It's very clear that she really, really loved the victim in this case. And if we're really honest, Paul Hicks sort of had a victory on the front end. He was at liberty all these years before his sidekick, Steve Gates, finally got a conscience and cracked and went to police and came forward. And but for that, he really could have pulled this off. So as we say, justice oftentimes is, not to sound trite, like the IRS. It's slow, but eventually gets you. And this is it. So he had his life, he had his heyday, his day in the sun, and now it's time to pay the piper.
Oh, the IRS.
IRS. You're right about that one, Philip.
All right, Philip, enjoy your hacienda in Mexico.
Have some pina coladas for us?
Yes. It's Friday somewhere.
And by the way, they have a true crime.
Oh, good. Okay.
They have a true crime scene down here, by the way. What do they call it? It's called Criminales Reales, you know. So if you do a little research on it, yeah, there's been some serial killer type activity down here, and they're very much into it. It's fascinating stuff. So.
Okay, investigate for us, Philip.
Be careful.
Yeah.
We want you back.
Be well, everyone.
Bye, Philip. We'll see you later.
It's Friday. All right, Aunt and Uncle are next. Stay with us.
School shooting that broke hearts around the country and broke trust with law enforcement.
Now, the officer sworn to protect those students faces a jury.
The Uvalde School Massacre Trial. Live coverage today on Court TV.
Tonight on Closing Arguments, who would kill a beloved Ohio dentist and his wife? We're diving deeper into the murders of Spencer and Monique Tepe with the very latest in this investigation.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
In Ohio, Paul Hicks faces life in prison after being convicted in the cold case murder of his wife. Her name was Regina.
Prosecutors say that he knocked Regina unconscious before leaving her body in her Camaro, then driving that car into a pond. The case was unsolved for nearly 24 years. He got away with it, basically. But he was arrested last year when his buddy, who was his alibi, felt bad and came clean.
Right now, we've been watching Paul's sentencing hearing this afternoon. Let's go back into the courtroom for more victim impact statements.
Jennifer Ballenworth.
And I understand you're speaking on behalf of someone?
My father.
All right. And his name?
Denny Patrick.
All right. You may proceed.
Donnenwirth. I stand here today carrying a pain that words can barely hold. The horror was not just in the moment Regina's life was taken, it was in the long, unbearable moment that came before it. Watching someone you love being psychologically and emotionally destroyed, knowing they are suffering, knowing they are afraid, being powerless to stop it. That is the kind of torture that never ends. It plays over and over in your mind long after the world expects you to move on. While Regina was being tormented, Paul went on to commit other acts of evil as if her suffering meant nothing, as if her life was disposable. That is a truth that will haunt us forever. The cruelty was not accidental, it was deliberate. And the damage did not stop when her life was taken. It spread through everyone who loved her. Paul was not born a monster. Monsters are made. They are created through choices, through entitlement, through being enabled and never held accountable. Over time, Paul was allowed to believe he had power over others and that he could have control, harm, and destroy without consequence. And that belief turned him into exactly what we see today. But Regina was everything he was not. She was a beautiful spirit. She carried light, kindness, and warmth into the lives around her. She mattered. She mattered deeply. She was loved. She deserved safety, peace, and a future. Instead, her life was stolen in the most cruel and senseless way. We are not just grieving her death. We are grieving the life that she should have lived, the laughter that we can never hear again, and the moment the moments that were taken from her and from us. No sentence, no punishment can ever truly balance what was lost. But accountability matters, and truth matters, and Regina's life matters. Today, I ask that she be remembered not as a victim of violence, but as a human being whose life had value, whose spirit deserved to live free from fear. And I ask that the weight of what was done to her never be minimized, forgotten, or excused, because the damage caused by this violence will last a lifetime. Regina's light did not deserve to be extinguished, but it will not be erased.
Thank you.
Your Honor, next would be Melody Patrick, aunt of Regina Rowe.
Very good. Patrick, if you can give your name for the board.
Melody Patrick.
And who would you like me to know?
MELODYPATRICK. First off, I would like to express and thank you to the state, BCI, Dan Caceres, Micah Alt, James Sitterly, BCI Doug Burke, and his team. We have been committed to seeking justice for Regina. Not only did we lose Regina, but Lysella died from a broken heart, and Montana was ripped away from her mother and family that loved him more than anything and tried to protect him. Although justice has been granted, we will never stop making sure you serve life or in prison. Paul Hicks.
Thank you.
Next, Your Honor, Regina's uncle, Carl Patrick.
Sorry, Mr. Patrick.
Carl Patrick with a C, P-A-T-R-C-K.
And what would you like me to know?
Your Honor, this case could have been solved 24 years ago if the Huron County Sheriff's Department and Dane Howard would have done their job. But they didn't, so I want to thank you, this court, and the jury for getting justice for Regina and my family. Also want to thank the BCI, Micah, Dan, and Doug, and the Huron County prosecutor, Jim, who did an extremely well job for getting us justice. As far as saying anything to Paul, he don't care. I'm not going to say anything. Only thing I got to say to him is get used to prison food and don't drop the soap. Thank you, Your Honor.
Yes, Judge. Judge, you heard all the facts. There's no need to go into a rendition of facts.
Well, that one was short and sweet, huh?
The old "don't drop the soap" comment from the uncle. We saw that during the trial too. You know, Hicks, he just sat there like he never emoted any emotions. He looked like, you know, Gene Stallings losing a game. It was something else, and he's doing it again. It doesn't seem to affect him, and that irritated them.
Yeah, it definitely did.
Because he didn't search for her when she was missing, and now they get the last word. That's what sentencing's all about.
Yeah. Okay, well, that's going to do it for us right now. But coming up, the judge sentences Paul Hicks, so that's going to be a big moment. We'll be right back.
Plus, Uvalde will go back to Texas. Stay with us.
Welcome back to Court TV Live. I'm Michael Ayala. Court TV is in Ohio this Friday afternoon, where a man is being sentenced today for the death of his wife 24 years ago. Now, last month, the jury found Paul Hicks guilty of kidnapping and murdering his wife, Regina Hicks, whose body was found in a pond days after he filed for divorce in 2001. The prosecutors say that Hicks rendered his wife unconscious before placing her in the passenger seat of her car and then driving it into a pond where she drowned. Now, we just heard victim impact statements from several members of Regina's family. Well, now the state is giving their closing argument to the judge. Let's go back into court.
You heard it all over nearly a 2-week period of time. As far as a record for the defendant has misdemeanor convictions from Norwalk Municipal Court for persistent disorderly conduct, which was a reduced domestic violence, with the victim being Regina Hicks. He has a persistent disorderly conduct from 2005. He had an unlawful hunting with a gun, 2010, and he pled guilty to misdemeanor insurance fraud in Claremont County in 2022. That was originally indicted as an arson. Your Honor, the sentence for kidnapping under Senate Bill 2 is 3 years to 10 years. The state's going to ask that you impose that sentence consecutive to the sentence that you have to impose for the murder, which is life without the possibility of parole till after 15 years. Your Honor, multiple prison sentences here are required. They serve a necessary purpose to protect the public from a killer, from committing future crimes. Consecutive sentences, Your Honor, would not be disproportionate to the seriousness of what the defendant did here and the danger that he poses to the public. These two offenses, the kidnapping and the murder, were committed as part of one course of conduct, and the harm that both caused was so great or unusual a death that no single prison sentence adequately reflects the seriousness of what the defendant did. Regina Hicks was a 25-year-old woman, a mother, a daughter, a sister, a cousin, and a friend. He kidnapped his wife, knocked her out, dragged her into a car, and then drove her car into a pond, drowning her. To not sentence the defendant consecutively would be rewarding him for the kidnapping. It would be like, okay, you can have a kidnapping and you can get away with it, and we're not going to punish you for it. We should not be permitting people who commit crimes such as the defendant did that lead to murder with not being punished fully for what he did. Even in the jail, as he's awaiting sentencing, he can't follow the rules. He's using somebody else's PIN to make phone calls to his girlfriend and other people. He's allowing people to use his PIN to make phone calls, and the jail is going to deal with that. He can't follow the rules in society. He can't follow the rules in the jail. Justice, Your Honor, calls out for consecutive sentences for Paul Hicks for what he did on October 18th, 2001, and the state demands it. Thank you, Your Honor.
All right, thank you. On behalf of the defense, Mr. Rich.
Thank you, Your Honor. May it please the court, counsel. Your Honor, I think the state conceded it was a course of conduct, and the kidnapping was a part of that conduct. He has no prior felony convictions. I believe the appropriate sentence in this case is the mandatory minimum, 15 to life. Thank you.
Very, very good. Thank you. The court then, in considering the sentencing here, has considered the purposes of sentencing contained in revised code section 29.
Your Honor, may we approach real quick?
You may.
All right, so while they go to that sidebar, quickly, I just want to point out that the state really pushing for those consecutive sentences on the kidnapping and the murder charges. The defense saying, look, he doesn't have any other felony convictions, and asking for the minimum, which is still 15 to life in prison. If you add on the maximum for the kidnapping, that's an additional 10 years that he could get, making it 25 to life, which would be, again, as a man of, I think in his mid-50s or so, could be really tantamount to a life sentence. But the defense really has an opportunity here, and I thought to really say a little bit more about this crime, because when I think about it, and when I think about the victim impact statements, the real harm in this crime was lying about it for 24 years and not giving the family the opportunity to properly grieve. And we heard that in some of their victim impact statements. All right. That sidebar, I believe, is over. Let's get back into court.
To address the court with regard to sentencing?
No, Your Honor.
Very good. Then at this time, the court has considered the overriding purposes of sentencing contained in Revised Code Section 292911A. The court's cognizant of those purposes, including the protection of the public from future crimes by the defendant, the protection of the public from future crimes by others, and the punishment of the defendant using the minimum sanctions the court determines will accomplish those purposes without imposing an unnecessary burden on state or local government resources. In attempting to achieve those purposes, the court has considered rehabilitation of the defendant, providing restitution to the victim and the public, the need to incapacitate the defendant, and the deterrence of the defendant and others. And looking at the principles of sentencing in 292911B and C, and in passing this sentence, the court has tried to achieve those purposes by making this sentence reflect the seriousness of the defendant's conduct and its impact on the victim. Also to be consistent with sentences for similar crimes and similar defendants, and the court will not base this sentence on race, ethnicity, gender, or religion. And looking at the factors to consider in felony sentencing at this time, the court would note that here the harm suffered was the most significant, that being death to Regina Hicks in this case. Obviously, the relationship with the victim played a large role in this offense, the defendant being the husband and father of Ms. Hicks's child. In addition, the crime is one of domestic violence as committed in the vicinity of the child, in that it was alleged that Montana was in the vicinity at the time that these offenses took place. As far as it being less serious, there are no factors that would apply. As far as recidivism being more likely, there was a minimal history as detailed by the state with regard to misdemeanor offenses. More significantly, there's been no evidence of any type of remorse on Mr. Hicks's part. He managed to keep this from coming before the court for nearly a quarter of a century and did nothing to avail himself of the opportunity to bring it forward and bring it to closing so that the family, the friends, and the community could begin healing in the matter. Instead, he let it fester for all of these years, all of this time, without any sign of remorse whatsoever. As far as recidivism being less likely, the defendant did not have any delinquency adjudications. As far as leading a law-abiding life, it could be argued that he did so for a period of time after this, but keeping this a secret to himself over time, I can't find that that would be a factor that would apply. As far as the sentencing, the court is required under count 1 to impose on the murder, an unclassified felony, a 15-year-to-life sentence, and I will do so. The statute would indicate that since he's not likely to be able to pay a fine, then a fine would not be appropriate. As far as counts 2 and 3, those are merged for purposes of sentencing into count 1. As far as count 4, the kidnapping, a felony of the first degree, the court believes here that actually the maximum sentence would be appropriate. The court's going to impose the 10-year maximum. I do find this to be the worst form of the offense. Here the victim was rendered unconscious, and then due to the kidnapping, taking her from where she was to another location, resulted in her drowning and suffering death as a result, direct result of the kidnapping. It's hard to imagine a circumstance that would be more detrimental or more harmful or more horrible than what has occurred here. As far as those sentences, the court does believe that running them consecutively would be appropriate. There is no reason for any leniency in this case. The defendant had the benefit of roaming free for the last quarter of a century before facing justice here today. The court's total sentence then would be 25 years to life. The court is going to order that costs be paid. As far as those consecutive sentences, the court does believe that they are necessary and are appropriate to adequately protect the public from future crimes and to adequately punish the offender. The sentences are not disproportionate to the seriousness of the conduct, nor the danger that he poses to the public. Further, the court finds that at least 2 of the multiple offenses were committed as part of 1 or more courses of conduct. The harm caused by the 2 or more multiple offenses was so great that no single prison sentence for those offenses committed would be adequate to reflect the seriousness of the defendant's conduct. In addition, the offender's history of criminal conduct and the factors in this case would demonstrate it is necessary to protect the public from future crime. As far as prison programming, risk reduction and IPP program would not be available, nor would a transitional control program. And looking at credit for time served, and looking at earned time credit, as to the offense of kidnapping, it would be under the earlier version of the law, which means that potentially you could get...
All right, so the judge sentencing Paul Hicks to 25 years to life in prison, the maximum on the kidnapping, saying he found no room for leniency because he had the benefit of being free for the last 24 years or so. All right, we'll take a break. We'll have more of that sentencing when we come back. Keep it here on Court TV.
School shooting that broke hearts around the country and broke trust with law enforcement.
Now, the officer sworn to protect those students faces a jury.
The Uvalde School Massacre Trial. Live coverage today on Court TV.
Tonight on Closing Arguments, who would kill a beloved Ohio dentist and his wife? We're diving deeper into the murders of Spencer and Monique Tepe with the very latest in this investigation.
Closing Arguments tonight at 8, 7 Central, only on Court TV.
In the state of Ohio versus Paul Daniel Hicks, 2025-0284, on the indictment for count 1 being murder, the jury finds the defendant guilty of murder of unclassified felony. It's dated December 19th, 2025.
After just under 3 hours of deliberations, the jury found Paul Hicks guilty in the 24-year-old cold murder case of his wife. Hicks now faces the possibility of life in prison for the drowning death of his wife, Regina. Her body was found in the passenger seat of her Camaro, submerged in a pond 3 days after Paul had filed for divorce. We'll get you back inside that courtroom now, where the judge is continuing to hand down his sentence.
Up to 8% by following the rules and regulations of the Department of Corrections. As to the portion of the sentence that applies to the kidnapping, potentially could increase that to 10% if you completed certain programming, but they would reserve the right to reimpose that time if you violated the rules. Do you understand that? I'll indicate the defendant nodded yes. As far as post-release control, that's not a factor here because your only avenue of release in this case would be through parole after you had served the remainder of your time on the murder charge. I did provide to your counsel a violent offender status sheet. Have you had a chance to review that with counsel?
Yes.
All right. I am going to ask that you sign in acknowledgement of that. I hear you have been convicted of or pled guilty to murder, which is a qualifying offense as described under the statute. You're required to register in person with the sheriff of the county in which you establish residency within 10 days of coming into that county, or if occupying a dwelling of more than 3 consecutive days in the county or 14 or more days in a calendar year. You're also required to comply with all the listed requirements for a period of 10 years unless the court were to determine otherwise. Here the court determines that you would be required to provide the sheriff certain information, including your full name and any alias that might be used, your residence address, your social security number, any driver's license number or commercial driver's license number or state identification card that has been issued to you, information regarding the offense which you were convicted of or pled guilty to, and the name and address of any place where you are employed, the name and address of any school or institution of higher education that you attend, the license plate number of each vehicle owned or operated by you or registered in your name, and any description of any scars, tattoos, or other distinguishing marks on your person. You're required to provide the sheriff with your fingerprints and palm prints, and the sheriff would also obtain a photograph of you at the time of the registration. After the date of initial registration, you're required to re-register annually. He will be updated and amend any information described and that has changed and provide any additional information requested at the county sheriff's office within 10 days of the anniversary of the calendar date on which you were initially registered. If you do change your residence address, you have to provide written notice of that change to the sheriff with whom you most recently registered and to the sheriff in the new county where you intend to reside. Any failure to register could result in criminal charges. Do you understand those conditions?
Yes.
They would come into play if you were released on parole. That's when your period of registration would begin. Do you understand that?
Yes.
As far as judicial release, there is no ability for the court to release you early. Again, your only avenue of relief here would be through the parole board. As far as rights of appeal, you have an automatic right of appeal because you did go to trial, and here the court did impose a maximum sentence as well as a consecutive sentence. The Court of Appeals, your notice to the Court of Appeals for the appeal needs to be filed within 30 days from the date of the judgment entry that imposes your sentence. Do you understand that?
100%.
All right. As far as the purposes of appeal, I did speak with Attorney Rich prior to coming on record. It was indicated that you had contacted the State Public Defender's Office and they were willing to take the case for appeal on behalf of the defendant.
May it please the court, that's correct, Your Honor. I spoke to Mr. Clark yesterday and Mr. Patterson. The state was willing to take on the case. I discussed that procedure with Paul on Wednesday. I spoke to the Ohio Public Defender's Office yesterday. I would ask that the court put on a contemporaneous order or entry with the sentencing entry appointing the Ohio Public Defender for purposes of appeal.
All right, very good. As far as the jail time credit, there is 263 days that you have previously served that would apply to the sentence that the court's handed down here. At this time, I am going to remand you to the custody of the sheriff, and I will release bond. I do want to thank all of the attorneys that participated in the matter. You handled it very professionally all the way through. I also want to thank the members of the jury that were here. We took up 2 weeks of their lives as well, and they were very dedicated, and I do appreciate all of their service. At this time, then, we will take a recess unless there's further matters from the council.
There are, Your Honor. Just to protect the record, note the defense's objection to consecutive sentences, please, and then also note the objection to the maximum sentence on the kidnapping.
It will be noted as well.
Additionally, I asked that there was property seized during the investigation of this case from Elisa Carroll. She's present in the courtroom today. I asked that that property be returned since it's not being used for evidentiary value at this point. Finally, I think the court's aware Paul was indigent. I would ask that the court waive costs and fines as a result of him being indigent. Thank you, Your Honor.
The court didn't impose any fines. The court will waive the costs in this matter given the length of the sentence that has been handed down. As to Ms. Carroll's property, I'm going to ask that the state and defense discuss if they can reach a resolution. If they can't, I'll address it by motion.
Your Honor, those properties were seized pursuant to search warrants signed by an Erie County judge. So I think the plan would be to work out whatever Anthony wants back, then go back to Erie County and have that judge that issued the search warrant order the property released back to Lisa Carroll.
All right. And again, if you can handle it amongst yourselves, that's fine. If you need court intervention, you can approach the court by motion.
And just so the record's clear, Your Honor, it's my understanding the state is not opposing that.
No.
Okay. Thank you.
All right. Is there anything further then?
No, sir.
I do hope for the family and friends of the victim here that are present today. It's been a very long time for you to wait for justice. I hope this brings you some closure.
All right, so the judge basically expressing the sentiments I had. I hope it brings them some closure. They waited over 25 years for some semblance of justice, and I hope, again, that they do get some closure from this. That man there, Paul Hicks, sentenced to the maximum under the circumstances, 10 years, the maximum for the kidnapping, to run consecutive with the 15 to life on the murder. So he is the property of the Ohio State Corrections Department for the next 25 years at a minimum. That doesn't even mean he's going to get out. That just means he's eligible for parole after those 25 years. So he'll have to behave. Sounds like he was having some issues behaving as well, even leading up to this sentencing. All right, let's bring in our guest. Joining us is trial attorney Marlo Greer. Marlo, great to see you. Thank you so much, as always, for being on the program with me. Want to get your reaction. As I mentioned, the maximum sentence handed down by the judge here, basically saying he found no reason at all for leniency, that this guy had been out for the past 25 years, and he was lucky to have that.
First of all, great to see you as well. And my first thought was, can you say narcissistic personality disorder? That man shows no remorse whatsoever at all. He couldn't even pick up his own pen to sign the document that the court wanted him to sign.
Did you
He
catch
basically
that?
nudged his attorney.
I said the same thing. I said, there's no reason he couldn't have reached over and grabbed that pen. I thought the same thing. I said, maybe he's connected at the hip. That's the only thing I thought. You know, sometimes they have the handcuffs connected to something around the waist. Let me check. Let me look real quick. Now, that may be the case, Marlo. It looks like
it may be the case,
I don't know. I had the same thought.
I mean, his attorney, yes. Yes, his attorney said it right there, and it just, you saw on his face. I mean, there was nothing about his demeanor that indicated remorse. And one of the other things that I thought, and I'm wondering if you did too, is I thought he's going to appeal, and he thinks he's going to win that appeal because there's nothing in his face. He's just completely blank, and so either he's, you know, a sociopath that would be that way, or he just really thinks he's going to win that appeal.
Yeah, there's a sense of arrogance that you get from him regarding this particular situation. Let's talk quickly about that appeal. He is obviously indigent. The Public Defender's Office will be handling that appeal. They have a special department to do that, very talented attorneys there. The one thing that I think might be an issue that the defense challenged going into trial was the bringing in of all his domestic violence issues, as well as this idea that he tried to set her up by planting drugs in her car. They did get some testimony from his buddy who said that he had asked him to make the call to check up on the car, to get the police to check up on her. Anything there that you can read into it, anything you might remember from the trial that could be grounds for success on appeal?
I think that the prior acts, and so we call that 404B evidence, which is acts in conformity therewith. And so bringing in the domestic violence will, I believe, be an issue because you can bring in prior bad acts only if under certain circumstances like pattern. And so they probably brought it in under pattern of conduct as opposed to, hey, he's a bad guy, right? That's what the prosecution is going to say. We brought this in to show this pattern against this woman, not just that he's a bad guy, not that he killed her, but that there's domestic violence. And I think that there's definitely grounds for appeal based on that. I don't see a lot of grounds on the drugs in the car. I'm not quite as familiar with that situation and why the court decided to let that in, but I really don't see a bunch of reasons to challenge that. I think it will be the 404B.
Yeah, I might agree with you. The judge basically saying that this was really nothing more than a continuation of that domestic violence. So they did see it as a pattern to show a motive here. So that's kind of what he ruled. We'll see what the appeals court says.